those after marking them.
Actually, yes, Sachin Kumar. That's
Sachin
right,
Kumar
yeah.
and others versus Delhi Subordinate Service Selection Board, my lord.
Yes.
If I may make this submission, my lord, neither do I have the standing.
Just
my
show
lord,
the
nor-
paragraph and be done with it.
What I am submitting here, my lord, that this is one process of selection which has invariably been interfered with by the courts, my lord. The commissions, they have always shied away from taking
that is
corrective, but
your-
every time it is
this
judicial examination, my
This
lord.
is in continuation of your argument that the justice is not only the sole, doing justice is not only left to courts, it is for everybody, the first responders.
My
That's
lord,
right.
Not just that, as my lords have been time and again. My lord yesterday had observed that in a judicial recruitment examination, my lords, despite having conducted that on the administrative side, scrapped it on the judicial side because there were defective questions. Now, my lord, this Sachin Kumar, it furthermore, my lord, as in reinforces that proposition and the sanctity of these processes of selection, my lord. Paragraph number 35 at page 655.
Yes.
The position of law. My lord, a very interesting expression has been used there. In deciding this batch of SLPs, we need not reinvent the wheel. It is a case like that only. It is a tried proposition of law now. If there is a failure on your part, you only are going to face the brunt. And my lord, there is no hardship involved. They just have to conduct the examination, and that is what they do, and that is what they have to do. Grace would have required them to raise their hands and say, all right, we will conduct another one. Over the last 5 decades, several decisions of this court have dealt with the fundamental issue of when the process of examination can stand vitiated. Essentially, the answer to the issue turns upon whether the irregularities in the process have taken place at a systemic level so as to vitiate the sanctity of the process. These are the cases which border upon or cross over into the domain of fraud, as a result of which the credibility and legitimacy of the process is denuded. This constitutes one end of the spectrum where the authority conducting the examination or convening the selection process comes to the conclusion, even or circumstances, the process has lost its legitimacy, leaving no option but to cancel it in its entirety. Where a decision along those lines is taken, it does not turn upon a fact-finding exercise into individual acts involving the use of malpractices or unfair means, where a recourse
That's right. Over and over again, the court is emphasizing on the systemic fraud and irregularities, not the isolated.
It is not an individual having been wrong, man. We say that
No, you don't turn it that way. Individual is wrong. That's not the intention.
They are not saying that, but we are also not saying it, my lord.
You don't convert it to your advantage.
I'm not, my lord.
Now, this is with respect to holding of examination, holding an examination to be bad, vitiated by fraud, vitiated by irregularities,
My lord.
where there could not be any segregation. They say that large-scale irregularities, including those which have the effect of denying equal access to similarly circumstanced candidates, are suggestive of a malay which has eroded the credibility of the process.
It is not a case of taint at all, my lord, in the present case.
No, that's
it is
right.
systemic alone. It is not a case that they have been benefited or the question paper was leaked and these are the beneficiaries or these are the ones who are
They
given
repeat
certain
again.
advantages.
They repeat again later, where the recruitment to public employment stands vitiated as a consequence of systemic fraud.
My lord.
Systemic, in general parlance, is being understood as systematic. No, they say
systemic.
Systemic fraud or irregularities, the entire process becomes illegitimate.
Systemic is, my lord, a part of that system. The process, the procedure that there is a failure on their part. There is a clear-cut failure in the instant case, my lord, and then emphasis on Article 16, my lord. In the middle, my lord would find a fair and reasonable process of selection to post subject to the norm of equality of opportunity under Article 16(1) is a constitutional requirement. This, I believe, my lord, was trying yesterday, but the expressions that I was using perhaps were not as accurate, my lord. But this is all that I submit. There is a systemic failure on their part.
That's right, but this
Magnitude may kindly be seen.
statement may not be directly read and imported
Not at all.
in a situation where a second examination has been held because of segregation.
It has been held because of segregation only, man.
It has been. Because
segregation is not.
There was a large-scale complaint from one center.
But it is segregation. The basis of segregation is not tainted or untainted. The basis of segregation and reconduct, we won't call it, my lord,
You
segregation.
can call it.
Reconduct is
by
because
the-
there is
by-
systemic failure.
Anyway, yes.
Then, my lord, then of course, this is not platitudinous exactly, my lord, but these are certain things that we need not repeat to ourselves. Now, my lord, para 64 at page 672. I'm very sorry, my lord, for emphasizing on things. 655, paragraph 35, right above that, my lord. The heading was capital F, the position in law. This position is law is what we are relying upon.
Oh,
This is the basis and this is the grundnorm for the present case for us. 672, my lord. Para 64. My lord,
Yes.
G, margin G, my lord, at the bottom, my lord, is fine.
yes.
In the present case, we have seen, in the
Yes.
present case, as we have seen, there was a basic denial of equal access to tier 1 examination. The nature of the allegations which were found to be substantiated upon a careful examination by the first committee showed that the credibility of the process itself has been eroded. In such a situation where a decision is taken by the government to cancel the entire process, it cannot be held to be,
This was against the decision of the
my lord,
government.
the
to
government to
cancel.
cancel. But the principle remains, my lord, that the
Huh?
sanctity has been eroded.
Yeah.
And my lord, it is not those who were beaten up before the conduct of the examination who were responsible for leaking out the question paper. The commission could not keep its house in order. It were their invigilators, it were the members of state services, etc., my lord, who were entrusted with that duty. There was a complete failure on their part. For a state like Bihar, my lord, which boasts about its population exceeding 10 crores now, cannot hold an examination for 4 lakh. If that be so, my lord, then I would not go very far. This is my state, but there is a failure somewhere. And that must be cured before it is too late. There has not been a single examination, my lord, where the courts have not interfered or the model answers were not changed right since that 48 to 52nd. I'm making this submission, my lord, on record. There are judgments in which this honorable court has cautioned them. I'll be getting those judgments if need be, my lord, that this is not how public service the
That's
examinations
right.
are
After
treated.
Sachin, which case?
My lord, this is 2015 6 SEC 573.
Name of the case?
Tanvi Sarwal.
Tanvi Sarwal, where again the examination was
My
cancelled.
lord. Paragraph number 18, my lord. I'll just give the previous, my lord. It's 594 if I'm not wrong. Para 18, my lord.
Yes.
As has been noticed herein above, the disclosures in the investigation suggest that the benefit of answer key has been availed by several candidates taking the examination by illegal means. Though as on date 44 such candidates have been identified having regard to the modus operandi put in place, the number of cell phones and other devices used, it is not unlikely that many more candidates have availed such a new advantage, being a part of the overall design, and in the process have been unduly benefited for the other students who had made sincere and genuine endeavors to solve the answer paper on the basis of their devoted preparation and hard labor. In view of the widespread network that has operated as the status reports disclose and the admission of the persons arrested, including some beneficiary candidates, we are of the opinion, in view of the strong possibilities of identification of other candidates as well involved in such malpractices, that the examination has become a suspect. I have not made these suspicions on facts, my lord, but the learned counsel who had assisted my lords on these points before me had brought to the notice of this honorable court, my lord, not the PIL, my lord. I'm absolutely categorical about, my lord, not about adopting anything that has been spoken in that PIL.
Judgments are the same. Fortunately.
But, my lord, I must convey my reservations over a few points.
Yes. Yes,
My
you have made it.
My lord,
All right.
senior, my lord, paragraph
Next.
number,
We have noted this paragraph. This is
there are two
Tanvi.
more paragraphs, my lord.
Yes.
Para 20 and para 23. These are the consequences of this, my lord, doubt being there. It cannot be brushed aside, my lord. Para 20, 23, my lord, I'll be placing, my lord. It is again, my lord, on the facts of the case. We are aware that the abrogation of the examination, this is the angst, my lord, sometimes the concern and the reason behind not interfering in such matters, my lord. But what the Honorable Apex Court has to say is, we are aware that the abrogation of the examination would result in some inconvenience to all concerned, and that extra time would be consumed for holding a fresh examination with renewed efforts therefore. This, however, according to us, is the price the stakeholders would have to suffer in order to maintain the impeccable and irrefutable sanctity and credibility of a process of examination to assess the innate worth and capability of participating candidates for being assigned inter se merit positions commensurate to their performance based on genuine and sincere endeavors. It is a collective challenge that all the role players would have to meet by rising to the occasion and fulfill the task ahead at the earliest so as to thwart and abort the deplorable design of a mindless few seeking to hijack the process for selfish gain along the unscrupulous beneficiaries thereof. Though the board has taken a plea that having regard to the enormity of the exercise to be undertaken, the same cannot be redone before 4 months, we would emphasize that this is an occasion where the board ought to gear up in full all its resources in the right spirit in coordination with all other institutions that may be involved so as to act in tandem and hold the examination afresh at the earliest. A wishful thinking, my lord, if it could come true, this could be the penultimate paragraph of the judgment as may be passed by this court. This sums it up, my lord.
Yes.
This is the situation that we are faced with. They are not saying that this does not happen or that did not happen. They say we have declared.
All right. Next.
This is an old judgment celebrated one, my lord. Union of India versus O Chakradhar.
Union of India versus?
Union of India versus O Chakradhar.
O Chakradhar.
Chakradhar. 2002-3 SEC, page 146, my lord. Para 8 I'd be relying on. Para 8 at page 151.
Yes, sir.
In our view, para 8, man.
Yes.
In our view, the nature and the extent of illegalities and irregularities committed in conducting a selection will have to be scrutinized in each case so as to come to a conclusion about future course of action to be adopted in the matter. If the mischief played is so widespread and all pervasive, affecting the results so as to make it difficult to pick out the persons who have been unlawfully benefited and wrongfully deprived of their selection, in such cases it will neither be possible nor necessary to issue individual show-cause notices to each selectee. The only way out would be to cancel the whole selection. Motive behind the irregularities committed also has its relevance. We are still, my lord, at a preliminary stage.
Now, if
the demand for Chinese goods,
Mr. Srivastav, you know the law that if answer has to be inferred from logic, from deductions, then the objection is not sustainable.
It is not, my lord.
You know that.
We would not be going that far, my lord, for no valid reason. This is the stage, my lord. This is my most respectful submission. And as regards, my lord, when there is a doubt, with respect to the correctness of the question papers, the course as is required to be adopted, my lord, is decided in a case that has gone, of course, from our own state, my lord. 2013 4 SEC, page 690, Rajesh Kumar and others versus State of Bihar. Para 21, my lord, is available. Page 698, my lord.
Yes.
There is considerable merit in the submission of Mr. Rao. It goes without saying that the appellants were innocent parties who have not in any manner contributed to the preparation of the erroneous key or the distorted result. There is no mention of any fraud or malpractice against the appellants who have served the state for nearly 7 years now. In the circumstances, while the inter se merit position may be relevant for the appellant, the outcome of the latter need not be an inevitable and inexorable consequence of such a revaluation. No, it is not that. I'm sorry, madam.
This paragraph doesn't
I'm sorry, my lord.
tell us.
I'm sorry, my lord.
Para 15. So you are reading para 15 only, no?
My lord, there in our view, no merit in the contention so far as, my lord, it has been stated in this judgment, my lord, that this is the appropriate course to be adopted. I'll just ask somebody, my lord, I lost the correct footnote. I'll just find that out, my lord, and in the meantime, I'll be referring to this one.
Now read that first plus item, you will find it. I mean, though it refers to para 15 only, but para 15 is couched in a different
My lord,
way.
yes,
Talks
that
about-
expression is
but
not
the necessary law position has been explained. The model key answer
Selection.
which is used for evaluating, the first one.
My lord, in case of erroneous evaluation where examinees are not at fault at all held.
No. If the model answer key which was used for evaluating the answer sheet was itself defective, the result prepared on the basis of same could be no different.
My lord, this is para 15.
But para 15
Para 15
is
is not
different.
fine mention.
Now,
It must be some other.
The division bench of the High Court was therefore perfectly justified in holding that the result of examination insofar as the same pertained to A series was vitiated. This was bound to affect the result of the entire examination for every candidate, whether or not he was a party to the proceeding. That's right. We don't find it in para 15, this entire
This
paragraph.
expression is not. Anyhow, my lord, I just
Oh,
find it
you
very-
rely on this.
My lord, now we are in the habit of control F. That is why it's become very difficult for us to find where in these books, my lord, control F is. Now, my lord, one judgment, 2000, this is, my lord, Rachel and others versus Rajasthan Public Service Commission, my lord. 2018, 8 SCC 81. Page 87. Page 81, my lord. 2018, 8 SCC, page 81. Para 15 and 16, my lord. Page 87.
You see with this one. Para 15.
My lord, yes. At page 87, my lord. The issue pertaining to scope of judicial review of correctness of key answer has been considered by this court time and again. This court has entertained such challenges on very limited ground and had always given due weight to the opinions of subject experts. A three-judge bench of this court in Kanpur University versus Samir Gupta had occasion to consider a case where challenge was made to the key answers supplied by the paper setter with regard to multiple choice of the objective type test for admission in medical courses through combined pre-medical tests. The High Court, while considering the challenge of the candidates to various...
No, that's right. They have taken note of
My lord. And
different
para
judgments,
16, my lord.
including the one from Bihar, which paragraph 15, which is
My lord,
different
yes.
from the plaster. And then lastly, para 19. Please read it out.
The key answers prepared by the paper setter or the examining body is presumed to have been prepared after due deliberations. To err is human. There are various factors which may lead to framing of the incorrect key answers. The publication of key answers is a step to achieve transparency and to give an opportunity to candidates to assess the correctness of their answers. An opportunity to file objections against the key answers uploaded by the examining body is a step to achieve fairness and perfection in the process. The objections to the key answers are to be examined by the experts and thereafter corrective measures, if any, should be taken by the examining body. In the present case, we have noted that after considering the objections, key answers were published by the Commission. Thereafter, several writ petitions were filed challenging the correctness of the key answers adopted by the Commission. The High Court repelled the challenge, accepting the views of the experts. The candidates still unsatisfied have come up in this court by filing these appeals. This court, while hearing these appeals, found substance in some of the submissions raised before us. An appellant satisfied this court that certain answers need re-examination by experts. This court issued directions on so and so. My lord, the expression "no stone to be left unturned" must be having some value, my lord, in human existence.
Added to it would be that within a time frame, it should not disturb the academic schedule.
My lord, it
We will do
cannot
that.
be.
Let's see.
It was the first instance, my lord, examination.
You also want to cite Vijay Singh.
Vijay Singh, my lord, we could not. My lord, para 15, it's there, my lord, in the middle somewhere. Para 15 of Rajesh Kumar and the state versus state of Bihar, my lord. 2013 4 SEC, my lord. It will be page 696.
Para 15.
Para 15, my lord, in the middle. E. On the right hand margin, my lord, will find E. The High Court has aptly...
Same, what we read in the plus.
My lord, yes,
All
the
right.
plus.
And Vijay, it has been summarized.
Updated for the, my lord, yes.
Where it is? You have brought it.
2018 only, my lord. We could not get it here, my lord. So, I be for
Vijay, they say 1, 2, 3, 4, 5, 6,
this has
7.
been, my lord.
All right.
That is also 2018 only, my lord.
I would not remember the
My
year.
lord, we'll get that. So, I'll sum up by
Up
submitting,
till
my
now,
lord,
we have relied on Richel and Vijay.
my lord, that
while
judicial
deciding cases.
appointment.
All right.
matter.
So you give a list of those questions where the answers
My
are
lord, yes, I
defective,
will furnish
which
that.
requires a rechange. We'll put it to the BPSC. We'll
And
see.
my lord, there is no question of any inconvenience. That is their job.
No. Inconvenience to, I mean, at what level? Inconvenience to students who believe, I mean, their statement should be taken note of.
The inconvenience that they are pleading, my lord, the commission, that it will get you.
That we'll see.
That does not hold any
Let's see.
obligation.
Yes, Mr. YouTuber. तो फिर इनको कब शुरू करने कहेंगे? अब आज के बाद तो हम सुनेंगे नहीं.
I have still my objection in hearing him.
No, Mr.
This
Shahi,
is my lordship. This
We
court
will-
should
we
not
will-
be allowed to be
let
converted
us.
into.
No, it will not be. We just want to hear him 2 minutes. Yes, not more than 2 minutes. Don't repeat.
My lordship, I will base my argument on the doctrine of legitimate expectation. The violation-
Doctrine of legitimate expectation. All right.
Point number 2, I will base my argument. Apart from the violation of Article 14 and 16, there is a violation of Article 21.
You don't
also.
have a legitimate expectation of anything. Legitimate expectation of being given the opportunity of testing your intelligence, of being selected, of, I mean,
And also
in examination
and last point,
system, in recruitment process, there is no
My lordship,
legitimate
last point, there is a
expectation.
systemic failure which I will prove through the judgment which Supreme Court in
Tanvi.
Vanshika,
Yes.
I would like to say, on what basis Supreme Court reached to the conclusion that there was no systemic leakage of the paper? It reached to the conclusion on the basis of the data analysis, and this data analysis was done by the IIT Chennai.
We have observed it in the earlier part of the discussions.
So the same point. Just two
Mr.
years,
What is your name?
Pragesh Prasunso.
Mr.
Pragesh.
Pragesh.
Yeah.
Now, I had forewarned you earlier also. See, this is not the process of the court. Your petition is only in the pipeline. There is an objection to your being heard. But otherwise, we are of the view, cutting across all these technical formalities, that we will hear you. But if you repeat,
I'm not repeating, sir, but
we have
framing
read,
that argument.
for your satisfaction, we have read Vanshika, we have read Tanvi,
Yeah.
we have read all other cases that you
I'm
cite.
just saying, sir. Just saying. Just give me 2 minutes, sir. I'm just saying.
2 minutes, right by watch. We can
that-
extend it by 1 more minute. Yes.
So in that particular judgment, the Supreme Court is right of comparison of data of each particular center year by year, previous 2 years. What my submission is that in the second re-examination, 4th January, the success ratio 19.6% on an average. But if we look at the success rate of 22 centers in segregate, that may spike to 22-25%. Because my lordship, this is not a one-off event. Because in Delhi, what is study you have told, in Delhi, because we have option to choose the centers. That's why in Delhi the success rate is higher. Also, this is not a one-off event. In Delhi, always the success rate is remain higher. But in this particular case, this success rate is a one-off event. This is not a mere chance. This is not a mere coincidence. Rather, this is a systemic failure, which I will prove, my lordship, allow.
Yes. 2
Yeah.
minutes more. Yes.
My lordship, in this particular case, what happened? This result have been prepared, two different exams have been taken, and this result have been prepared by merging the raw marks. This is where this entire problem has arisen.
Merging the
Raw marks of the two examination. The combined merit list have been prepared on the basis of the raw marks obtained by the candidates on the two
wrong
different
marks.
tests.
What do you mean by wrong marks?
Raw marks means what they actually what they have obtained in the examination. But my lordship, here the problem is that whenever examination takes place on two different sections, it is practice, then there has to be some methodology adopted. I would like to place my reliance on the very celebrated judgment of the constitutional bench, Sanjay Singh versus UPPSC, in which the only methodology was flawed, the entire result was cancelled. Only the formula was flawed. What I'm trying to say, my lordship, in this particular case, so what happened? The two results, the two sections marks have been combined, and what happened? That the 90 marks cut off have been framed for UR general. But point here is that, my lordship, 90 marks for section 2, like on 4th of Jan, and 90 marks from section 1, that is on 13th December. These are not same. Well, on prima facie, it may appear this numerically this is same, but this is not, my lord, same. This is what I'm going to prove, my lordship, here. My lordship.
Yes.
My lordship, on 13th December in Patna itself, there were more than 60 centers. None of the
Mr. Pragesh, this aspect is in our mind. This is in our mind, and therefore we have, let the BPSC answer. Now we are aware of that.
Now I would like to submit one more thing. NTA publishes result on the basis of this normalization methodology, and they based on this research, on basis of this research paper. This is the research paper. Yeah. On the basis of that, they publish the result. This research paper itself says that when the examination held on multiple sessions, on the second page, my lord, or the second set of sites, it is written that when the examination is held on multiple set, then there has to be some methodology adopted. They have
yes.
They have relied on this. What I'm trying to say, my lord, in 4 January session, there were absolute number 1165 candidates were selected.
You have raised such a big issue. The question is that the answers are wrong. The framing of question is wrong. You are asking for this kind of exercise for normalization.
No, sir, I'm not asking. What I'm trying to say, when 2 sets of papers are there has to be some methodology. There has to be backed by some statistical data. What I'm trying to say. We cannot publish a combined merit list from the 2 different sets of students which were assessed on 2 different level of paper.
No.
What I'm trying to say,
you cannot postulate like this. You can only say that it is always better if 2 sets of examinations are taken on 2 different dates with different questions. Therefore, normalization should be done.
My apologies, my lordship. What I'm trying to say, in absolute number, my lordship, 1165 candidates have been selected from the 4th January session. What in terms of, even if we take the highest ratio of the 13th December session, 9%, it should have been 550, 500. That means, my lordship, there are some genuine students who have been from 13th December batch that have been denied the rightful admission to write a mains examination. In that perspective, I would like to say quote an example. In 2014 UPSC examination, the rank 1 air single has secured rank 1, but she got only 1 mark above the cutoff. That's why there are many genuine students, more than 600, 700 from 13th December batch, they have been denied the rightful admission because of this faulty procedure, my lordship. This is what, and this systemic failure is completely brought up by the BPSC itself. This I will prove, my lordship, if you allow.
All right. Don't need to prove this. We cannot.
That Bapu Pariksha Parisab Center में जो कुछ हुआ, my lordship. This is what they had deliberately did it. This is what I am going to prove, my lordship. This was
the commission created disturbance.
Yeah, my lordship. This was not by mere chance. This is not by mere coincidence. This was a deliberate attempt by the commission to create a chaos at that particular center. This is, I know, my lordship, this is a very serious allegation, but I will defend it, my lordship.
They don't take notice of it. Anyway, that's over the process. We'll get to know. Apart from this, this is good that you have pointed out. Yes.
One more point, my lordship. In Bapu Pariksha Parisab Center, the seating arrangement was made in the 273. And SOP, it is very categorically pointed out that in any room there cannot be a student without 12 multiple of 12. But any seating arrangement should have been multiple of 12 because there is a logic behind that. Any TES back.
That's right. Your the other persons who argued, they have talked about
But-
violation of SOP.
But my point here is that, my lordship, why this precaution was not taken before the conducting examination, while it is had completely taken. In fact, when BPSC had a reassessment of this entire situation after the conducting examination, in that particular report, it has never mentioned that there are 273 students sitting in that particular room. That side is mismanagement. They completely put the onus on the students. They have conspired it. They have made it, but rather this is a conspiracy of BPSC itself.
Prima facie, we do not accept this argument. You may suggest this, but we are not accepting this argument. We have accepted what you have said, what made sense to us. Right? All right. Thank you. Thank you. Are you a technical person by profession?
Sir, I am a BTech engineer.
You are a BTech engineer. All right.
But I have written sir BPSC examination 5 times. I have appeared in interview also.
All right.
Thank you, sir.
All right. Thank you. Yes, Mr. Shai. You first have your say and then answer our questions. Come here. The mic here is better. Or if you find yourself convenient.
I'll aptly summarize, my lord, their argument to say that if much ado about nothing.
Mister, why are you opening the passage for them to retaliate? You argue your case. They have so much to say against commission, to the extent of saying that you have created the chaos.
My
and
lordships,
when you create the chaos, it becomes...
when litigation is sponsored, these kind of narratives will emerge.
All right. Yes. Start.
So for first case,
The PIL.
PIL, my lordships, I'll straightway refer to a division bench judgment which has considered, my lord, the role of a wayfarer in espousing the cause of the applicants. Public interest litigation wala. Public interest PIL पर तुम्हारे साथ भी प्रॉब्लम है, भाषण देने से तुमको फुर्सत मिलता है। अरे जिसमें
आपने तो फोटोकॉपी रखा है ना दो?
हाँ?
आपने फोटोकॉपी रखा है ना दो?
हाँ नहीं भाई, जिसमें उन्होंने कहा कि PIL नहीं होगा। अरे यार मैं पढ़ा हूँ, नहीं बहुत मुश्किल है तुम्हारे साथ। उन्होंने कहा कि पब्लिक इंटरेस्ट लिटिगेशन नहीं होगा।
Mr. Abhinav Srivastava and Ms. Runa, please just jot down the questions on which you have objections, which has not been clear, and give it to us by today, by evening. And any sequence that you want to say, any judgment, do that. And Mr. Giri, that's true for you also. जो भी क्वेश्चन की गड़बड़ी है वो हमें लिस्ट करके दे
डेफिनेटली आईए में लिख दिया, अलग से भी लिख
कर कागज पर देना, अपने दिया है क्या दिया है, बस वो भी करना है ना।
ठीक है, उसको एक अलग
बाय इवनिंग टुमारो
उसको सीट पर एक अलग से लिख दीजिए,
अलग से जो भी आपका पॉइंट समराइज करके एक जगह लिख दीजिए।
ठीक है।
So that we do not miss on to any one of your contentions. Short, 5 pages. Questions and otherwise 1 or 2 pages on your just summary of your argument. Not necessarily detailed arguments, paragraph, 2 paragraphs.
ये नहीं है,
Keep it limited to 5 pages, 7 pages.
हम आप पर रिलाई कर रहे हैं। आप
Outer limit 10, not beyond, by tomorrow. Outer limit 10 pages. So that we don't open the files again.
I'll give that judgment, my lordship.
That was very important. We wanted to hear that because we permitted the person to argue. Read it out if you want.
1 minute, my lord. Okay. He has jumbled up.
Oh. Is it the same process of jumbling up the questions?
My lordship.
BPSC is having some problems.
If my friend is appearing for commission, then it's a different matter. He can appear for commission and appear for the government, or appear for both. So I do not think the state should
Go- I believe government has no role.
Government's role comes when
Government role
when the students prevail upon the government to cancel the exam, and that
or
comes
government
before us.
role will, my lord, start when BPSC makes recommendation. I believe, my lord, my friend is aware of these principles.
I'm on different point. My friend can argue for everybody. In this case, my friend is arguing for the commission or for the government. So that is the.
No, he is
because
appearing
government
for-
has also onerous duty to see that Public Service Commission functions well. Government is not a part of the Public Service Commission.
No.
Nor the Public
He
Service
is appearing in
Commission.
his
Nor the
capacity.
Public
He is
Service
appearing
Commission
in
is
his
a
capacity
part
as
of the
Mr. PK
government. Both are independent entities. I will consider this aspect.
No, that's all right. I mean, I do not find any flaw in this.
We are seeing a separate constitutional body. Government is sovereign power. Now, if an opposite argument is advanced, my lord will consider that aspect. All. क्या तो रोल रिकमेंडेशन के बाद आता है गवर्नमेंट
ये नहीं, हम
अरे
बैठ कर
गवर्नमेंट के
निकालेंगे।
फंक्शनरी नहीं है, गवर्नमेंट के वकील हैं और यहाँ बीपीएससी के वकील हैं। अभी ये कौन सा ऑब्जेक्शन है? ये ऑब्जेक्शन
हम नहीं कह रहे हैं। हम कह रहे हैं
देखिए साहब,
आजकल इनका ना
हम पेटी वो ऑब्जेक्शन, इनकी ऑब्जेक्शन भी हमने टर्न डाउन की। इफ आई हैड टू हियर दैट पर्सन
हमने
फ्रॉम यूट्यूब,
objection नहीं किया।
द थिंग इज दैट वी शुड कम आउट विद ट्रूथ एंड विद करेक्ट डिसीजन।
Yeah, yeah.
अब ये सब ऑब्जेक्शन आप करिएगा।
ना, हम-
ही अपीयर्स एज अ
नहीं किया है।
सीनियर
हम तो
एडवोकेट।
शुरू में कहा कि दोनों की तरफ से अपियर हो सकते
इंटरफेस है, अब इसको कहाँ
हैं।
कहाँ तक
स्टेटस
आप
दोनों का डिफरेंट है, इतना ही होता है।
अभी सरकार आ नहीं रही है, सरकार डिसीजन नहीं ली है। वो अगर हम डायरेक्शन देंगे सरकार को टेक अ डिसीजन, तो बात दूसरी है, तब ये डिफेंड करेंगे, जो करना हो करेंगे। नाउ ही इज अपीयरिंग फॉर कमीशन।
ठीक है।
the list started with my lordship's solitary ground that the examination selection test at Bapu Sabhagar was cancelled, and during course of selection test question paper was taken out
This was 13th of December.
13th of December. Question paper was taken out, as a result of which the question paper got circulated all over the state and the question paper leaked. This is the foundation of, my lord, the list which started. The agitation was also directed with that assertion that question paper got leaked and it got circulated to various centers. And therefore, purity of the selection test has been compromised and a fresh selection test is required to be held. This is the crux, my lordships, of,
This is the argument.
this is the argument, in fact. Later on, they have expanded to include that certain questions
That's
are
right.
wrong. So the argument has two facets. One, whether question paper leaked and whether commission justifiably should hold a re-examination of the entire state, or having a selection test confined to one center where selection process got disrupted would suffice. And the second limb is regarding, my lordship's, wrong question or wrong model answers. So it is in two compartments. I will be answering one by one, my lordships. Now, certain figures should be relevant. ये उसका दिया हो तुम, हाँ मेन का दो। अरे उसमें हम नोट किया
PIL.
There were admit cards were issued, my lord, to 4,80,359 applicants.
4 lakhs.
Admit card was put on my lordship's website.
4,83,000.
For 80,359. Out of which 4,48,470 only downloaded it.
Yes.
लिखे हो तुम, हाँ 3,23,047. ये भी फिगर गलत है. This was, my lord, on 13/12. In Bapu Sabhagar, there were 912 centers across 36 districts of the state of Bihar.
Total centers across.
912.
Yes.
Including Bapu Sabhagar, spanning across 36 districts, not 38.
36.